In Law and Order, there are remarkable instances where judges rise to the forefront, delivering scathing remarks and unforgettable moments within the courtroom.
Department 2, you were relentless. You stabbed, you stabbed, you stabbed, you stabbed, you stabbed until he was dead.
Today, we present a compilation of the top 10 savage judge moments, leaving the legal community and audiences astounded and captivated. From blistering comebacks to jaw-dropping put-downs, these judges exhibited no mercy when it came to maintaining order and serving justice. Get ready to witness these savage judges with us. Number 1. Judge Jorge Rodriguez Chomat. In a notorious case that gained widespread attention, Penelope Soto, an 18-year-old from Florida, found herself in a courtroom facing charges of possession of illegal substances. Her appearance before Circuit Judge Jorge Rodriguez Chomat quickly became viral due to her disrespectful behavior and defiant attitude. The judge's subsequent response showcased a savage judge moment that left an indelible mark on legal history. During the hearing, as the judge raised Soto's bond from $5,000 to $10,000, she could be seen laughing throughout the proceedings, displaying a complete lack of seriousness. In an audacious act of disrespect, she proceeded to flip off the judge and uttered the words, "Go, expletive, yourself." This shocking display of contempt quickly earned her a charge of contempt of court and a 30-day jail sentence. However, the story took an unexpected turn. At a later hearing, Soto tearfully expressed remorse, offering a genuine apology to Judge Rodriguez Chomat. She admitted to being under the influence of illegal substances and alcohol during her initial appearance, explaining her inappropriate behavior. Moved by her repentance and recognizing her potential for rehabilitation, the judge dropped the contempt charges and vacated her jail term. Instead, Soto was offered an alternative path toward redemption. Her lawyer revealed that she would participate in an illegal substance court program, a rehabilitative initiative that focuses on treating addiction to all sorts of substances. Such programs often result in charges being dropped for first-time offenders who successfully complete the treatment. This case serves as a reminder of the power and authority wielded by judges in the courtroom. Judge Rodriguez Chomat's swift and decisive response to Soto's disrespectful behavior showcases the boundaries and respect required within the legal system. While the incident became infamous for its savage judge moment, it also highlights the potential for redemption and rehabilitation within the criminal justice system, offering Soto an opportunity to address her underlying issues and turn her life around. Number 2. Judge John M. Ott and other Georgia Supreme Court justices. Christopher McNabb, a Georgia father, will remain in prison after the Supreme Court of Georgia upheld his conviction for taking the life of his infant daughter Kalia in 2019. McNabb and Courtney Bell, the girl's mother, were accused of taking their daughter's life while under the influence of illegal substances and being in a violent relationship. McNabb recently filed a motion for a new trial, claiming that there was insufficient evidence to convict him. He also argued that his attorneys did not adequately object to evidence regarding his illegal substance use, physical violence, and the fact that Bell was his first cousin. However, the Newton County District Attorney's Office stated that the Supreme Court found these claims to be unfounded, leading to the affirmation of McNabb's conviction. After the trial, McNabb received a life sentence without parole for the crime and an additional 10-year sentence for concealing the death of the Kalia. McNabb will serve his sentence at Hays State Prison. During the trial, Nabb expressed his disbelief at being found guilty of harming his children. He stated that he had never laid a hand on them, and that just because he had domestic issues with his partner didn't mean he would harm his children. Nabb emphasized that there was no evidence proving his involvement in harming his own flesh and blood, asserting his innocence and his opposition to child harm due to his own experiences as a victim. However, his defense did not prevent the judge from delivering a severe punishment. In response to Nabb's claim of innocence, the judge challenged him by asking what punishment should be given to the real perpetrator of the crime. Nabb responded by suggesting life imprisonment. Considering his response and the evidence presented, the judge delivered a harsh sentence to McNabb. The judge stated that on the charge of malicious death, McNabb would be sentenced to life imprisonment without parole. Additionally, he received a consecutive sentence of 10 years for concealing the death. Christopher McNabb's conviction for taking the life of his daughter was appealed, but the Supreme Court of Georgia upheld his conviction and punishment. Despite McNabb's motion for a new trial, the court found no merit in his claims and maintained his life sentence without parole. The details of the crime involved the use of illegal substances and a difficult and violent relationship between McNabb and Bell. Meanwhile, Nabb and Bell expressed their innocence and opposition to the heinous crime, but their defense did not prevent the judge from issuing a severe punishment. Number 3. Judge Murphy. In this case of Brevard Court, Judge Murphy became a viral meme in 2015 due to a physical altercation with public defender Andrew Weinstock. The incident unfolded when Weinstock refused to waive his client's right to a speedy trial. Murphy responded angrily, shouting at Weinstock and expressing his frustration. He even made a threatening remark, stating that if he had a rock, he would throw it at Weinstock. He ordered Weinstock to sit down and assured him that he would handle the situation without assistance. However, Weinstock stood his ground, asserting his right to be present and represent his clients. This exchange of words escalated further, with Murphy suggesting that they go outside and engage in a physical fight. Astonishingly, they proceeded to do so, leaving the courtroom attendees amazed. Shouts between the two could be heard in the background during the brawl. After the fight concluded, the onlookers in the courtroom began clapping and cheering. Both men accused each other of initiating the physical altercation. Weinstock claimed that Murphy had struck him twice in the face, while Murphy accused Weinstock of punching him in the chest. It was later revealed that a deputy had to intervene and separate them. Following a disciplinary hearing, Murphy was fired from his position due to his appalling behavior. The Florida Judicial Qualifications Commission initially sought a 120-day suspension, a $50,000 fine, and mandatory participation in a mental health therapy program. However, the Florida Supreme Court rejected this proposal, citing concerns about potential future misconduct resulting from the fist fight. Murphy's complete lack of self-control during the incident became a national spectacle and an embarrassment not only to himself, but also to Florida's judicial system. Given the significant loss of public confidence in the judiciary resulting from his misconduct, removal from his position was deemed an appropriate sanction. Number 4. Judge William Bowler. During the sentencing hearing, tension rose between the judge and one of the defendants, LaVon Turrentine. Turrentine, age 21, stood before State Supreme Court Judge William Bowler, having pleaded guilty to second-degree vehicular death. The charges stemmed from a tragic accident that occurred in April of the previous year, where 8-year-old Toonami Filbert lost his life. According to officials, Turrentine was instructing 18-year-old Brianna Hightower to drive when she struck the young boy as he ran across Porter Avenue in Buffalo. Notably, Hightower did not possess a driver's license at the time. Compounding the tragedy, after the collision, Turrentine and Hightower switched seats in the vehicle. However, while Turrentine was behind the wheel, he struck the boy again, resulting in his death. Initially released on bail, Turrentine was later arrested for possession of narcotics and driving the same vehicle with a suspended license. Judge Bowler expressed his displeasure, admonishing Turrentine for his actions. He highlighted that driving again after causing a fatal accident was a clear violation of the law and a demonstration of poor decision-making. Turrentine tried to explain that he wasn't joyriding, but the judge remained unsatisfied. The courtroom exchange did not end there as tensions escalated further. The fireworks in the courtroom were expected to be discussed further during the evening news. Meanwhile, Turrentine received the maximum sentence and faced the possibility of spending 7 years in prison. In contrast, the female involved in the incident, Brianna Hightower, was charged as a youthful offender. She pleaded guilty to reckless driving and was released. Prosecutors argued that she did not commit the action that directly caused the young boy's death. During the sentencing hearing for LaVon Turrentine, who pleaded guilty to second-degree vehicular death, a heated exchange occurred between the judge and the defendant. The judge expressed his disappointment with Turrentine's subsequent actions, leading to his maximum sentence and a potential 7-year prison term. Meanwhile, Hightower, who was charged as a youthful offender and had pleaded guilty to reckless driving and was released. The prosecutors determined that she was not responsible for the crash that resulted in the boy's death. Number 5. Judge Michael Cicconetti. Judge Michael Cicconetti, known for his eccentric and personalized approach to sentencing, has gained attention for offering unconventional punishments that fit the crimes committed. Rather than resorting to traditional penalties, he seeks to make offenders reflect on their actions and make amends. In one notable case, Judge Cicconetti ordered 18-year-old Victoria Bascom to walk 30 miles within 48 hours as punishment for skipping cab fare. The alternative was 30 days in jail. Bascom chose to complete the demanding walk, monitored by a GPS ankle strap, along with probation and restitution to the cab company. This was not an isolated incident. The judge also sentenced Alyssa Morrow, who neglected her dog in a dirty house, to pick up garbage at a dump. Morrow, grateful to avoid jail time, embraced the unusual punishment. Another example involved Jordan Walsh, who stole a bike and was given the option to ride a bike on behalf of a charity instead of serving a 60-day jail sentence. Walsh gladly took the opportunity to contribute to his community. Judge Cicconetti believes in a personal approach to each case, going beyond the mere application of the law. He recognizes that he can either follow the standard penalties or take the opportunity to connect with offenders on a deeper level, encouraging personal growth and community involvement. The judge's unique sentencing methods have garnered admiration worldwide. His willingness to think outside the box and seek alternative solutions has made him a distinctive figure in the realm of law enforcement. Judge Michael Cicconetti has gone viral online for his unconventional and personalized approach to sentencing. By tailoring punishments to fit the crimes committed, he aims to provoke reflection, personal growth, and community involvement in the offenders. His innovative methods have earned him admirers from around the world. Number 6. Judge John McBain. During the sentencing of Kemia Gamet, who was convicted of taking someone's life in cold blood, Judge John McBain had a furious outburst after she laughed at a statement from her victim's family. Gamet was sentenced to life in prison for assaulting her boyfriend, Marcel Hill, 11 times using a sharp weapon in a horrific attack. As Mr. Hill's aunt addressed the court, Gamet was seen rolling her eyes and snickering, displaying a lack of remorse and disrespect. Judge McBain, visibly angered by her behavior, interrupted her and sternly warned her to shut her mouth or face consequences. He expressed his disdain for her actions, stating, "I hope you die in prison. If this was a death penalty state, you'd be getting the chair." The judge's strong words conveyed his condemnation of Gamet's callousness and disregard for the gravity of her crime. Gamet maintains that she acted in self-defense, and her defense lawyers plan to appeal her sentence. However, Judge McBain's impassioned response reflected his frustration with her behavior and his belief that she deserved the harshest punishment available. His emotional outburst demonstrated his commitment to ensuring justice for the victim and his family, as well as his intolerance for disrespectful and unremorseful behavior in his courtroom. The judge's words carried the weight of his authority, reflecting the severity of the crime committed and the impact it had on the victim's loved ones. While the judge's comment about the death penalty may have been fueled by his emotions, it highlighted the depth of his condemnation of Gamet's actions. This moment in court exemplified Judge McBain's dedication to upholding justice and ensuring that offenders are held accountable for their actions. It also served as a reminder of the emotional toll that criminal proceedings can have on the victims and their families. Number 7. Broward County Circuit Judge Elizabeth Scherer. During the sentencing hearing for Nicholas Cruz, the convicted Parkland school criminal, Broward County Circuit Judge Elizabeth Scherer scolded members of the defense team for their behavior. The scolding came after defense attorney David Wheeler claimed that comments made during victim impact statements were made about his children, suggesting they were inappropriate. This led to a heated exchange between Wheeler and Judge Scherer. Broward County Public Defender Gordon Weeks initially raised concerns about the comments made during victim impact statements, stating that they were inciting violence. However, Judge Scherer dismissed the concerns, stating that most of the statements had been appropriate and it was best to move on rather than highlight a few inappropriate comments. Wheeler pressed the judge, asking if she would take action to prevent such incidents from happening again. He mentioned incidents of disrespectful behavior from the defense table, including gestures and laughing, and argued that the upset individuals in the courtroom had a right to express their dissatisfaction. However, Judge Scherer took offense when Wheeler claimed that the comments made were about his children. She responded by stating that she did not even know he had children and did not understand what he was talking about. She firmly told Wheeler to sit down and stated that he was out of line, ultimately excusing him from the courtroom and instructing him to sit with the chief public defender. The exchange continued as Wheeler retorted that he was the public defender, not an assistant. Judge Scherer clarified her instructions, asking Wheeler to ask the lawyer from his office to sit down and not say anything else. She deemed the mention of her children and the implied threat inappropriate and asked Wheeler to go to the back of the room. Despite attempts by Wheeler to intervene, Judge Scherer denied him a recess to speak with his attorneys and continued to scold Wheeler as he walked away. She reiterated that Wheeler had no right to suggest something about her children and deemed his behavior inappropriate and out of line. This incident showcased Judge Scherer's zero-tolerance approach to inappropriate behavior in her courtroom. She swiftly and firmly addressed Wheeler's comments, making it clear that bringing up her children was unacceptable. Her response demonstrated her commitment to maintaining order, respect, and professionalism during the proceedings. By addressing the inappropriate behavior and setting clear boundaries, Judge Scherer ensured that the focus of the sentencing hearing remained on the case at hand. Her actions underscored the importance of maintaining decorum and respect in the courtroom, even during emotionally charged proceedings. Number 8. Judge Gary Bennett of Elyria. During a video arraignment in Ohio, defendant Ebony Burks faced misdemeanor charges of assault and domestic violence. However, her contemptuous behavior during the proceedings resulted in her contempt sentence being raised multiple times by Judge Gary Bennett of Elyria. Burks's contempt troubles began when she realized that a no-contact order prevented her from returning to her home where she lived with her grandfather. Expressing her disagreement, Burks questioned the judge's decision, asking how he could tell her that she couldn't go to her own home. Judge Bennett firmly responded that he had indeed made that decision. Burks's defiance led to an initial 30-day contempt sentence. However, her behavior escalated when she held up her hand and walked away from the camera, resulting in an additional 60-day sentence. Despite the mounting consequences, Burks continued to talk back to the judge, with each retort resulting in an increased jail sentence. So what? 90 days. So? 120 days. Okay, and? 160 to 180 days. What else do you have to say? Judge Bennett informs her that he will not say anything until their next meeting in 6 months. Burks makes an off-camera remark, earning a 200-day sentence. Judge Bennett asks if Burks has anything else to say, and she responds with profanity, resulting in a 300-day sentence. Judge Bennett described the 300-day sentence as the longest he had ever imposed for contempt of court. This exchange showcased the escalating consequences of Burks's disrespectful behavior and her repeated failure to comply with the judge's instructions and maintain a respectful demeanor. Judge Bennett's firm response to Burks's contemptuous behavior demonstrated his commitment to upholding the decorum and authority of the court. Despite Burks's persistent arguments and defiance, the judge consistently imposed stricter sentences to maintain order and discipline within the courtroom. This highlights the importance of respecting court proceedings and adhering to the instructions and decisions of the presiding judge. It serves as a reminder that contemptuous behavior can have severe consequences, including extended jail time. Judge Bennett's actions aim to ensure that Burks understood the gravity of her actions and to maintain the integrity of the court's proceedings. Number 9. Jefferson District Court Judge Amber Wolf. During a sentencing hearing in Jefferson District Court in Louisville, Kentucky, Judge Amber Wolf was taken aback when a woman detainee was brought into the courtroom without proper lower clothing. The woman had been in custody for several days for failing to complete a diversion program for a 2014 shoplifting charge. Judge Wolf expressed her outrage at the woman's situation, noting that she appeared to be wearing only a long shirt and no pants. She questioned whether the situation was real and called it outrageous. The woman, who was wearing a University of Louisville t-shirt and yellow athletic shorts underneath, had not received a jail jumpsuit or feminine hygiene products since being taken into custody. The judge immediately took action and released the woman with a $100 fine and time served. She also made a phone call to the jail to address the issue. Judge Wolf requested that the detainee be provided with something to cover up with, expressing her concern for the woman's lack of appropriate clothing. She emphasized the fact that the detainee had been denied pants and feminine hygiene products for 3 days, calling it unacceptable. The incident was captured on courtroom video footage and gained attention when it was reported by local news. Judge Wolf's compassionate response and determination to rectify the situation were evident as she confronted the jail administrators over the phone. She held the woman in court until appropriate clothing could be provided, stating that she would not allow the detainee to return to the jail without the proper attire. The Louisville Metro Department of Corrections Inmate Handbook states that inmates should be provided with clean jumpsuits and bed linens before being assigned to permanent living areas. However, it does not specify a time frame for providing these items. When confronted with the claims made by the woman about being denied feminine hygiene products, jail spokesman Steve Durham responded by saying that the jail had an abundance of such products in the dormitory area and that there was no evidence of her making any requests during her time in custody. However, Judge Amber Wolf appeared visibly enraged by the situation during the courtroom video. Judge Wolf expressed her disbelief that the woman had been held for multiple days on what she described as a first-time shoplifting charge. She questioned the circumstances surrounding the case, suggesting that the prolonged detention seemed unjustifiable. The judge compared the situation to being in the twilight zone and expressed her confusion and frustration at what was happening. Judge Wolf firmly conveyed her view that the woman should have been held for no more than a day, emphasizing that the detainee herself bore responsibility for her initial arrest. However, the judge vehemently criticized the subsequent treatment the woman endured, deeming it inhumane and unacceptable. She expressed her sincere apologies to the detainee for the ordeal she had experienced, assuring her that such treatment was not normal. The judge's reaction showcased her empathy and concern for the well-being of individuals in custody. She recognized that while the detainee may have been at fault for her initial arrest, the extended period of detention without proper clothing and hygiene products was deeply troubling. Judge Wolf's heartfelt apology conveyed her commitment to upholding humane standards within the justice system and her recognition that every individual, regardless of their charges, deserves to be treated with dignity and respect. Number 10. Seminole County Judge Fred Schott. In a Seminole County courtroom, a judge had a heated exchange with a prosecutor over the dismissal of a guilty verdict in a DUI case, resulting in the judge's transfer from the criminal court division. The incident occurred on March 11th and involved Lisette Gonzalez, who was arrested for driving on a suspended license following a previous DUI arrest. Judge Fred Schott became angry upon realizing that Gonzalez's license should not have been suspended in the first place. The arresting officer, Michael Wagner, had failed to administer a blood alcohol test, but marked on the DUI citation that Gonzalez was over the legal limit. During the trial, Officer Wagner admitted to making a mistake, but the judge viewed it as perjury. In a heated exchange between Judge Schott and Assistant State Attorney Diana Mears, the judge accused Officer Wagner of lying on a sworn citation and requested that Mears charge him with perjury. Mears defended Officer Wagner, stating that he had acknowledged the mistake, but did not intentionally lie. In response to the situation, Judge Schott abruptly dismissed the charge. Gonzalez's defense attorney, Blaise Trettis, argued that a breath test was indeed available at the jail during the booking process, contradicting Officer Wagner's testimony. Trettis presented evidence from the breath test operator of the sheriff's office, who confirmed the immediate availability of breath tests. This conflicting evidence reportedly upset the judge. Following the incident, Judge Schott will be transferring from the criminal division to the civil division on April 13th. While a spokesperson for Judge Schott declined further comment, a statement acknowledging that Judge Schott had expressed frustration with certain aspects of the criminal caseload and had previously shown an interest in transitioning to the civil division was released to the press. On the 18th Judicial Circuit, Chief Judge John Harris released a statement that said, Managing a full-time criminal docket, whether felony or misdemeanor, can be very stressful, and Judge Schott has done a great job in that division for many years. Judge Schott has admitted that he has recently become frustrated in dealing with certain aspects of a criminal caseload. Because of this, and because he had previously expressed an interest in transferring to the civil division anyway, I made arrangements to allow him to make the move at this time. The state attorney's office plans to appeal Judge Schott's judgment of acquittal in Gonzalez's DUI case. The incident highlights the tension and disagreement between the judge and prosecutor, ultimately resulting in the judge's relocation to a different division.